What we're about to do is fund the Border Patrol and ICE through the entire Trump term because you wouldn't help us.
Imagine spending years doing everything right. You filed every paper, paid every fee, showed up to every appointment, learned the language, built a life. You followed the rules, every single one. And then one morning, without warning, without explanation, without any due process whatsoever, the government just stops, freezes everything, tells you that because of where you were born, not what you did, not who you are, your application is on hold, your work permit is suspended, your path to citizenship is canceled. Welcome to what hundreds of thousands of people from 39 countries experienced in the United States starting in late 2025. And if you think that story ended there, you need to keep watching because just days ago, a federal judge stood up and said in 135 pages of legal force, "Not on my watch." If this is the kind of story that matters to you, the kind that gets to the heart of law, power, and what America actually stands for, then hit that subscribe button right now. And if you know someone who needs to hear this, share this video with them today. This is the story of one of the biggest immigration legal battles in recent American history, and is still unfolding as we speak. Let's take this all the way back to Thanksgiving week, 2025. November 26th, to be precise. 2 National Guard soldiers are shot just blocks from the White House in Washington, D.C. Is a shocking, horrifying attack. The suspect is identified as Ramanullah Lakanwal, an Afghan national who had entered the United States legally in September 2021 as part of Operation Allies Welcome, the massive program that brought thousands of Afghans who had worked alongside American forces to safety in the U.S. after the fall of Kabul. Lakanwal had actually been granted asylum by U.S. Citizenship and Immigration Services back in April 2025. CBS News reported that he had been part of what were called Zero Units, CIA-backed Afghan intelligence forces, making him potentially a Taliban target. He was, in the eyes of the U.S. government, a refugee deserving protection. One of the 2 National Guardsmen he shot was killed. The other survived. The country was stunned, and the Trump administration moved fast. Faster than anyone expected. Within hours, USCIS posted on social media that, quote, effective immediately, processing of all immigration requests relating to Afghan nationals is stopped indefinitely. President Trump went on video calling for a reinvestigation of every single Afghan refugee who had entered under the Biden administration. By November 27th, USCIS Director Joseph Edlow announced that his agency was conducting, his words, a full-scale, rigorous re-examination of every green card for every alien from every country of concern. The Department of State immediately paused all visa issuance for individuals traveling on Afghan passports. Now here is where things escalated dramatically. What started as a response to a single horrific event rapidly expanded into something far broader. USCIS issued new policy guidance that applied not just to Afghans, but to applicants from 39 countries, countries that had already been targeted by the administration's existing travel bans. Across Africa, Asia, Latin America, and the Middle East. Countries including Iran, Nigeria, Venezuela, Afghanistan, and dozens more. Being from one of these nations was now declared a, and this is the official term, significant negative factor when your immigration application was being considered. But that was just the beginning. By December 2, 2025, a sweeping policy memorandum was in place. USCIS had done 4 things that would change the lives of hundreds of thousands of people. First, they imposed a global hold on all affirmative asylum applications, meaning nobody, regardless of where they were from, could get a decision on their asylum claim through the regular USCIS process. Second, they froze the processing of all immigration benefit applications for people from those 39 travel ban countries. Work permits, green cards, citizenship applications, all frozen. Third, they ordered a rear review, meaning cases that had already been approved under the Biden administration could be reopened and reconsidered. Fourth, they slashed the validity period for employment authorization documents, work permits, cutting them from 5 years down to just 18 months for many categories of applicants, including refugees and asylum seekers. And then came what many people considered the cruelest blow. Naturalization ceremonies across the country were canceled. People who had completed every single legal requirement, who had passed their civics tests, who had been approved for citizenship and were just waiting to take the oath of allegiance, those ceremonies were wiped off the calendar. Senator Chuck Schumer wrote a letter directly to USCIS Director Edlow, describing these cancellations as, quote, effectively denying access to citizenship, calling it a serious departure from legal responsibilities. Now, let's be honest about something, because this is where the debate really heats up. There are genuinely two very different ways to look at what the administration did, and both sides have people who feel strongly about this. You need to hear both. On one side, supporters of the administration's actions will tell you, look, a man who went through the legal immigration process, who was vetted, who received asylum, a man the system said was safe, walked up to 2 American soldiers and shot them. One of them died. If the system can fail that badly in one case, how confident can you really be that it isn't failing in other cases? The administration's argument was that national security is not something you get to be casual about. 200,000 refugee cases approved under the previous administration needed to be reviewed. 19 countries, now expanded to 39, had been flagged as high-risk environments where background verification is nearly impossible because those governments either don't cooperate with the United States or simply don't have functioning record-keeping systems. Director Edlow's position was straightforward. American safety is non-negotiable. Full stop. These are not frivolous concerns. Terrorism experts have long warned that while the vast majority of refugees and immigrants are law-abiding people fleeing violence and persecution, the sheer volume of applications processed during a chaotic evacuation, like Kabul in 2021, made rigorous vetting extremely difficult. There are legitimate, good-faith arguments that some review was warranted. But here is where the other side of this debate becomes impossible to ignore, and it is the side that a federal judge ultimately agreed with in stunning fashion. Because what Judge John McConnell found when he looked at what USCIS actually did is that this wasn't careful security review. This was a blanket punishment applied to hundreds of thousands of people based on nothing more than their country of birth. Not their individual records. Not their behavior. Not anything specific about them. Just, you were born there, so you're frozen. On June 5, 2026, Chief U.S. District Judge John McConnell, Jr., sitting in Providence, Rhode Island, released a 135-page ruling that is, by any measure, a devastating legal indictment of what USCIS had done. McConnell, an Obama appointee, vacated 4 of the administration's key policies. And he did not hold back. The judge opened his ruling with what amounts to a direct challenge to the administration's own favorite rhetoric. He wrote that in discussions about immigration, you often hear people say that if someone wants to come to America, they should follow the law and do things the right way. And he said this case is a perfect example of immigrants doing exactly that. Then he drove the point home, but the rule of law has to apply to everyone equally. USCIS, he wrote, has neither followed the law nor done things the right way. McConnell found that USCIS had violated the very immigration laws that Congress charged it with administering, as well as the administrative laws governing the agency's conduct. He concluded that the policies had thrown the lives of countless immigrants living in the United States into indeterminate legal limbo. He found that the agency had placed the lives of countless individuals on hold solely by virtue of their countries of birth. And then he went somewhere that few judges are willing to go. He said the national security justifications the administration offered were pretextual. That's a legal word that means we don't buy the explanation because the evidence points to a different motive. And what did the judge say the real motive was? Anti-immigrant sentiments. Sentiments that federal law forbids from influencing immigration decision-making. He backed this up by pointing directly to statements made by President Trump himself. At a rally, the president had said he was pausing migration from, and these are the president's actual words, hellholes like Afghanistan, Haiti, Somalia, and many other countries. Judge McConnell quoted that and said the government was asking the court to shut its eyes and ignore the strong evidence of anti-immigrant animus before it. He wrote that doing so would require, quote, profound naivete on the court's part. Let that sink in for a moment. A federal judge sitting in Rhode Island looked at what the president's own immigration agency did, looked at what the president himself said, and concluded that the stated national security rationale was a cover story for something else. Now, what does all of this mean in practical terms? What actually changes because of this ruling? Here's what the court ordered. Affirmative asylum interviews and decisions must resume nationwide. The freeze is lifted. USCIS must begin processing adjustment of status applications, that's the green card process, along with work permit applications, travel documents, and naturalization cases that were paused under the categorical country-based holds. The naturalization ceremonies that were canceled will now be rescheduled. Hundreds of thousands of people who have been waiting, in some cases for more than 6 months, watching their legal status deteriorate, watching their work permits expire, losing jobs, losing income, unable to plan their futures, can now move forward again. The ruling also addressed something particularly troubling, the rear review policy. Under USCIS's rules, the agency had been reopening cases that had already been approved under the Biden administration, essentially going back and reconsidering green cards and other benefits that people had already received. Judge McConnell vacated that policy as well, meaning previously approved cases cannot be reopened solely because of nationality or because of when the application was filed during that period. One of the organizations that brought the lawsuit was African Communities Together, a group that also has an ongoing case about conditions at 26 Federal Plaza, a notorious IC detention facility in Manhattan that has faced numerous allegations of inmate mistreatment. Another plaintiff was Dorcas International Institute of Rhode Island. Their CEO, Milagro Seek, responded to the ruling by saying, and I'm paraphrasing closely here, that these policies were wrong, plain and simple, and caused needless and profound fear and uncertainty for so many friends, neighbors, and co-workers. Dr. Omar Ba, the founder and co-executive director of Refugee Dream Center, which had seen its workforce training program devastated when immigrants could no longer obtain or renew work authorization, said the policies were wrong and that Friday's ruling was vindication. The Department of Homeland Security, which oversees USCIS, did not immediately respond to requests for comment on the ruling. So where does this go from here? Because if you've been paying attention to immigration legal battles under this administration, you know this is almost certainly not the end. The administration has two choices: comply with the order and begin processing applications, or appeal to the First Circuit Court of Appeals, and potentially all the way to the Supreme Court. Given this White House's track record, an appeal is nearly certain. And here is the critical question: the Supreme Court. We have a 6-3 conservative majority on that bench. That same court in 2018 upheld the third version of Trump's travel bans from his first term, concluding that the president has broad statutory authority over immigration when national security is invoked. Could a similar logic apply here? The key distinction, and this matters, is that McConnell's ruling is not primarily about presidential power to restrict immigration from certain countries. That question was largely settled in 2018. This ruling is about whether USCIS followed proper administrative procedures, whether the agency acted within the authority Congress granted it, and whether individuals receive the procedural due process they are legally entitled to. These are administrative law questions, and they present a different legal landscape than the raw travel ban debates of the first term. But make no mistake, the stakes could not be higher. Let me give you a sense of the human scale. At the time these policies went into effect, there were approximately 2.4 million pending asylum applications in immigration courts. The policies affected applicants across 39 countries, spanning 4 continents. Naturalization ceremonies were canceled across multiple states, leaving tens of thousands of people who had met every legal requirement unable to complete the process. And the reduction of work permit validity from 5 years down to just 18 months affected refugees, asylees, asylum seekers, parolees, and temporary protected status holders. For context, a work permit is the legal authorization to hold a job. Without it, you cannot work legally. And without legal work, the choice becomes working illegally and risking deportation, or having no income at all. Now let's zoom out, because this ruling does not exist in a vacuum. The Trump administration, since returning to office, has pursued one of the most aggressive immigration enforcement agendas in American history. Mass deportation operations, expanded travel bans, restrictions on asylum, attempts to end birthright citizenship, the use of the Alien Enemies Act, a law from 1798, for expedited deportations. And in nearly every major battle, the administration has collided head-on with the federal judiciary. What we are witnessing in real time is a fundamental constitutional stress test. How much power does the executive branch have to reshape immigration policy unilaterally, without going through Congress, without following normal rulemaking procedures? Supporters of strict enforcement will tell you the courts are overstepping, that unelected judges are second-guessing national security decisions the elected president is constitutionally authorized to make. Critics will tell you that without judicial oversight, the executive branch would face no check on using the immigration system as a tool of persecution against entire nationalities. Both arguments have constitutional merit. Both reflect genuine tensions built into the American system of government. And both will be argued extensively as this case moves through the appellate courts in the months ahead. What is not debatable is the impact on real people. People like the individuals who showed up at naturalization ceremonies and found them canceled with no explanation. People like the workers at the Refugee Dream Center who could no longer legally work because their employment authorization was suspended. People like the long-term legal residents from Nigeria or Iran or Venezuela who had been waiting years for their green cards and found themselves suddenly unable to get any movement on their applications, not because of anything they had done, but because of where they happened to have been born. One line from Judge McConnell's ruling has been widely quoted by legal observers, and I think it deserves to be heard in full context. He wrote that he was not going to allow the government to effectively invite the court to shut its eyes and ignore the strong evidence of anti-immigrant animus. He said that doing so would require profound naivete. A federal judge, a chief judge of a United States district court, looked at what this administration did, looked at how the president himself had talked about these countries and the people in them, and said in writing, "I see what this actually is." That is an extraordinary moment in American legal history, and is one that both sides of this debate should sit with and think carefully about. Whether you believe the administration was right to act aggressively in the wake of a National Guard shooting, or whether you believe those actions crossed legal and moral lines, what you cannot argue with is this: the system is working the way it was designed to work. A policy was implemented. People who were harmed by that policy had the ability to go to court. A judge heard the arguments, reviewed 135 pages worth of evidence and law, and issued a ruling. That ruling can be appealed. The appellate courts will review it. The system, for all its slowness and imperfection, is grinding through this question the way the Constitution intended. The question now is whether the administration will appeal and how quickly. Whether an appeals court will stay Judge McConnell's ruling while the appeal proceeds, meaning whether USCIS will have to start processing applications immediately, or whether the freeze could be reimposed pending further review. And ultimately, whether this case reaches the Supreme Court and what that court decides. For the hundreds of thousands of people whose lives have been on hold, the answer to those questions is not an abstraction. It is everything. Is whether they can go back to work next week, whether they will become citizens this year, whether they can stay in the country where they have built their lives. This is a story that is not over, not by a long shot, and we will be following it every step of the way. If you found this video valuable, please do me a favor right now. Hit the like button. It takes 2 seconds, and it helps this channel reach more people who deserve to understand what's actually happening in American immigration law. Subscribe if you haven't already, because stories like this one, the ones with real stakes and real complexity, are what this channel is built on. And share this video with someone in your life who cares about these issues, whether they agree with you or not. The more people who understand what's actually happening, the better the conversation we can all have. This has been a deep dive into one of the most significant immigration rulings in recent memory. Thank you for watching, thank you for caring, and I'll see you in the next one.